Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I'm going to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says, I've got to say this, so I've said it. But nothing prevents me from giving you an easy to understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. Ready? Today, I'm going to talk about what you need to know about what the disability carrier is looking for in your proof of loss, what you need to know about the proof of claim forms you'll be sent by the disability insurance carrier, and the role of your doctor in your application for benefits. Let's take a break. Once we get started, I look forward to talking to you about these great topics.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Ready to get started? Let's talk about what you need to know about what the disability carrier is looking for in the proof of loss. Now, the first thing you have to do when you've decided that you're going to apply for your disability insurance benefits is to put the carrier on notice of the claim. And you can call them up, or preferably you should send them an email or just send some form of a communication to them asking for the proof of loss forms. So got to put them on notice. And then when you do that, guess what happens? You're going to get lots of forms and more forms. So let's talk about the claim form. There is no uniform claim form language in disability insurance policies, but let me give you an idea of what an example might look like. It might say, we'll send you a claim form within 10 working days of receiving the notice of claim. If the claim form isn't received within 15 days after the notice of claim is sent to us, you, the owner, should write us a letter about the claim describing the cause and extent of your loss in detail. While the law policy will suggest here that you should write a letter, I suggest that you call the agent or contact your HR department to ask for the proper claim form. I don't like the idea of writing a letter describing the cause and extent of your loss in detail, because you don't know what on earth they're going to do with that information that you provide. You might provide too much information, not enough information. So I really think that you should be contacting the agent or your HR department to ask for the proper claim form. So you're providing them with just the information they need and no more. So what's the next form? Well, I said more forms and more forms. So first is notice. The next is going to be an application form. Now, the application form, again, is a form that is carrier specific. And it may ask you information about your basic demographics, your address, your date of birth, your occupation, when you became disabled, what the disabling condition is. I like to keep these short, sweet, and to the point. I don't like to go into any extensive detail unless I'm doing the application, because I know what I'm doing. And unfortunately, you don't. And it's pretty easy to make mistakes in the application by not answering the question correctly or not giving them the right information. Now, another important form is the occupation form. To me, this is going to make or break your application. Well, why do I say that? Because that's pretty dramatic. The disability policies will normally pay you 2 years of benefits for an inability to do your own occupation. And then the definition of disability will change to any occupation. You should get out that disability policy and read what the definition of occupation is. That occupation might be as it's performed in the national economy, might be performed according to a book called the Dictionary of Occupational Titles, or it might be as it's actually been performed for your employer or in your local economy. So before you fill out that form, you need to understand what the definition of occupation is. I tell my clients to work backwards. Well, what do I mean by that? When you think about the physical problems or the psychiatric problems or the behavioral problems that you have that have led you to file a claim for disability benefits, I want you to think about the occupational duties that you have that you're having trouble with or you can't do at all. Because we want to make sure that the occupational duties cover the duties that, in fact, you're having difficulty performing. So we don't really skip anything, because ultimately we're going to connect this with your physician. Now, your employer might have a description of your occupational duties, and you want to get that before you fill out the form. I think that's important because I ask my clients to get that occupational description form, job description form from the employer, and get out a piece of paper and write down what is not included in the employer's occupational description or job description, and what is included that they may be doing or not doing. So we want to get a clear idea of really what it is you're doing, because the carrier is going to contact your employer about your occupational description, because you didn't insure your job, you insured your occupation. So we want to make sure that you and your employer are on board, or at least the carrier knows that you may be performing this job differently than your employer's own job description. Now, that may not even matter if the definition of occupation is as it's performed in the national economy. So it really doesn't necessarily matter if your employer has you do something differently or admits something, because the test is not going to be how you performed it for your employer, but how it's performed in the national economy. And if you've got that, then you need to get out this old book called the Dictionary of Occupational Titles and try to find your occupation, because that's what we have to prove that you can't do. You can't do the material and substantial duties of your occupation as defined by the disability insurance policy. Now, the next form might be a training and experience form. And I will generally see that, particularly when the definition of disability is changing from your own occupation to any occupation. But that training and education experience form, called a TE&E, is also an important form. And all these forms you should be preparing accurately and completely. Now, if we are looking at a situation where your definition of disability is going to be changing, it's crucial that you understand the definition of sedentary occupation. Well, why is that? If the disability carrier determines that you can do sedentary work, their vocational evaluator will locate occupations that are both substantial and gainful. And it's going to be the basis for a claims denial, termination of your benefits. And it really doesn't matter if there's no employer that would hire you or perform any of the occupations that the vocational evaluator suggests that you could perform. Among the other important forms are the attending physician statement and sedentary restrictions and limitations information. Now, the carrier is going to, throughout the life of your claim, ask your doctor to fill out what's called an attending physician statement form, an APS form. Ostensibly, it's designed to ask questions about your physical restrictions and limitations, your psychiatric restrictions and limitations, and any behavioral problems that you might have. The problem with these forms is that they're designed to have your physician indicate that you have restrictions and limitations such that you can work in some capacity, particularly if we are in this transition stage from own occupation to any occupation. Because if you can do sedentary work, then your benefits are going to be terminated. You need to understand that these forms are not written in a way that allow the doctor to give an opinion that you're unable to work, or even that you can only do sedentary work. They're designed to lead your physician down the path of saying that you can work in some capacity. Obviously, that's a trick. I supplement the attending physician statement form with the applicable residual functional capacity form that's found in a Social Security case. Yeah, I know that your case isn't a Social Security case. Well, it might be. But for example, if you have a cardiac condition, I can assure you that the APS form isn't going to ask relevant questions about your cardiac symptoms and how those symptoms impact your ability to function. Yet if you look at a cardiac residual functional capacity form for a Social Security case, it asks questions about exertional impairments, non-exertional impairments, difficulty walking, sitting, standing, the impact of stress, and the side effects of medications. These are all things that you'll not see a traditional disability carrier APS form ask. Now, another form that is important is the activity of daily living form. I think that's a trap. it's an open-ended generic form that asks you to tell them what it is you do during the course of a day. Now, you may do a range of things. On a good day, you may do more than you do on a bad day. And the next day, you may suffer from what you did on that good day. I don't like these forms because they're open-ended. I prefer to try to give ranges of activity. So how much you can lift, sit, stoop, bend, that sort of stuff. But they're also using this to get information about what it is you do. Do you volunteer? Do you garden? Do you have any hobbies? What is it that you can't do anymore? Because ultimately this is a trap. It's used in several ways. It's used in conjunction with the attending physician statement forms, and it's used in conjunction with your medical history. If there's a difference between what you're telling your doctor, what you can do, about what a difference between what you put on your activity of daily living forms, that can set up a surveillance situation. It could also lead the carrier to say, we don't believe your doctor because you're telling us you can't do these things, but you're telling your doctor that you can do things that seem to be outside of your claimed restrictions and limitations or what the doctor has said that you could do. So these forms are used to create conflict, to attack the basis of the doctor's opinion, and to put surveillance on you. Now, you are going to be probably asked to sign a release. There's some controversy about releases. You have a duty to cooperate, which means that you should be signing the release, but I try to limit the release. How do I limit the release? I will limit in terms of scope and say you only will sign a release, but you got to put on that release the names of the medical providers is going to. I generally don't like my clients to sign open-ended medical releases that don't identify who it's going to go to. The second thing I try to do is to modify the release to say that it's only valid for 6 months. And the third thing I try to do is to put on the bottom of it that says any and all information that you obtain via this release has to be forwarded to me. Now, I also let the doctor know that I'm limiting the release so that my physicians aren't caught blind by a blanket request for information. So I'll tell them the release is only valid for 6 months, and I gave a release specifically to you and not a generic open-ended release. There's also some controversy about Social Security releases. Disability carriers want to get a copy of your Social Security file, and I think, quite frankly, they should. Why do I say that? Well, because I often argue, as many ERISA disability lawyers do, that if the carrier denies the file when they know that the claimant is getting Social Security, they have not done a full and fair review of your claim because they haven't gotten the necessary information that they need to evaluate the claim. Some people may say, well, that's confidential. Yes and no. What do I mean by that? It is got information about your earnings records, and what your Social Security benefits are. But at the end of the day, it doesn't matter because most disability policies say they have the right to reduce your benefits by the receipt of your Social Security benefits. So they're going to get that information one way or the other. I actually like to submit as part of any claim or appeal the whole Social Security disability file from beginning to end. Every piece of paper my client filled out, which of course I've reviewed, any information supplied by friends or relatives, the medical records, the attending physician statement forms, the CMEs, the actual decision of the judge. Why do I want that? I want them to have all of that information because I will take them to task, as have many courts, for not considering that information. So I would rather give them that information so that they have the ability to obtain a copy of your Social Security file and to review it. If you want to limit what it is you're giving them access to, you can. I don't think it's a very good idea because you have a duty to cooperate, and more importantly, more often than not, what's in that Social Security file is going to help your case. What do I mean by that? Under the case law, MetLife versus Glenn, the United States Supreme Court has said that a carrier has to take into consideration the Social Security decision and the information in the file. Now, sometimes it won't be favorable. Sometimes the judge is going to say that you can work in a sedentary capacity, but because of your age, you grit out. Well, age is never a factor in a Social Security or in an LTD case anyway, but the carrier is going to seize on that as a basis for denial. As a seasoned ERISA disability attorney, I can get around that. I can address that through my vocational rehabilitation counselor and explain what the grids are, explain why the age is not a factor, and explain that notwithstanding the finding of the judge that you can do sedentary work, that there are other conditions that the judge didn't necessarily consider in awarding that benefit, or that ultimately the judge did award the benefits notwithstanding the fact that you were in a sedentary capacity, and explain what the judge did and what that means in terms of the LTD claim. I don't want the carrier to just seize on some bad information or a bad decision, and that happens. I want to be able to control the narrative, even in the situation of a poor result in a Social Security case. I think not providing that information is just a recipe, ultimately, for disaster. Now, I also want you to understand that if you're a medical professional or a professional like an attorney, you're going to be expected to provide financial information, and that includes tax returns and your monthly or quarterly financials. A lot of my clients get upset about that, and I say, well, why are we getting upset about that? Because you have a residual disability provision in your policy. That means that potentially, if you've had an 80% loss of your earnings based on your before monthly income, we're able to collect residual disability benefits. And to do those calculations, I have to look at your income tax return. I have to look at your monthly financials, because I'm going to create a spreadsheet that explains why you're entitled to your residual disability benefits. It does the math. And then I correlate it, of course, with your medical to confirm that you had restrictions and limitations as of that date that will impacted your ability to earn your pre-disability wages. So I think that it's really important that we produce that information and that it's analyzed in a fashion that we can explain where the residual disability claim starts, where it ends, where the disability total disability claim starts. And I like to send all of this information, if necessary, together with the billing information and the CPT codes. So why do I want to do that? Because they're trying to determine what your occupation was at the time you became disabled. And they're going to do an analysis of your practice. So if you're a plastic surgeon, for example, they're going to want to know what different kinds of procedures you did, how many procedures you did, because as we develop the claim for residual disability benefits and total benefits, we want to show the nature of the change in the procedures or the number of procedures, the fact that you might be making referrals. And of course, that potentially can lead to them requesting your appointment book. I don't have a problem with any of this. I like to send it to them in a big shock and awe box that goes thud when it hits their desk, because I've answered every one of their questions. We've got this winning claims application with all the forms. If we've got a residual disability claim, I've done all the calculations. I've got all the supporting tax and financial documentation. I've got the medical records. I've got a vocational report if necessary that ties it all down to a specific date. So really, I think that a shock and awe application is the key to not only winning your benefits out of the box, but to maintain your disability benefits. You can see that putting together an application is not easy, it's not for the faint of heart, and it takes a lot of thought, coordination, and potentially calculations. Wow, that's a lot of information to absorb. So let's take a quick break, and when we return, I look forward to talking to you about what you need to know about the proof of claim forms that you'll be sent.